Welcome to Guts and Guns.
So today is April 1st, 2026, and depending on where you look right now, you're going to see two completely contradictory realities playing out.
Oh, absolutely. It's wild.
Right. Because on one hand, California just activated this, new wave of restrictions today, restrictions that make it harder to purchase a firearm there than like almost anywhere else on the planet.
Yeah, the friction is just massive.
But then, at the exact same moment, federal judges are quietly dismantling the very foundation of the state's oldest, most established gun laws. I mean, how can both of those things be happening on the exact same day?
It's essentially a massive system crash.
A system crash.
Yeah, exactly. I mean, if you imagine California's legal framework as a modern computer operating system, right? One that has been continually updated with like new patches and firewalls over decades to handle modern problems.
Okay, I follow you.
What's happening right now is that the highest courts in the country have just forcibly downgraded that operating system to an 18th century version. And as a result, all of the state's modern applications, the laws themselves, are just starting to crash.
And that is exactly what we are unpacking in this deep dive. We're looking at the mechanics of this collision.
And we've got some great sources for this.
We do. We're pulling from a stack of recent legal analyses, legislative breakdowns like California Gun Laws Explained, and constitutional philosophy summaries, specifically the California Gun Law Philosophy Clash.
Right. And actually, before we get too deep into this, I should probably jump in and set a quick ground rule for us and for you listening.
Oh, yeah, definitely. Go ahead.
Because, firearms and constitutional law are obviously deeply, deeply politically charged topics.
Very much so.
So I just want to explicitly say that neither of us is taking a side here today.
Right. Absolutely not.
Our job is simply to impartially report the facts, analyze the legal philosophies presented in these sources, and just help you understand why this clash is happening. We are not endorsing either the state's viewpoint or the opponent's viewpoints.
Exactly. We're just looking at the mechanics. Because whether you follow firearms legislation closely or, you've never touched a gun in your life, this legal battle is actively rewriting the rules for how the government is allowed to regulate modern technology.
And public spaces.
Right, and individual rights as a whole. But to really grasp why the system is crashing in federal court, you have to understand the sheer scale of the system California has actually built on the ground.
The regulatory reality.
Yeah. Let's start with the friction. What does it actually look like to try and buy a firearm in California right now, today?
Well, it requires navigating an incredibly dense web of verification. For example, let's look at the rule that just got tighter today, April 1st.
The 1 in 30 rule.
Right. So California has long had this 1 in 30 rule. It was originally designed to prevent gun trafficking. The idea was to stop someone from, buying 50 handguns out of the trunk of a car and selling them on the black market.
Makes sense.
But as of today, that rule is vastly expanded. You are now prohibited from making an application to purchase more than a cumulative total of 3 firearms of any kind within any 30-day period.
Wow. And that's just getting your foot in the door, right?
Oh, yeah. That's just step one.
Because if you want a handgun, you can't just walk in and point to whatever looks good in the display case. You immediately hit the handgun roster.
The roster is infamous at this point.
Right. And it isn't just a list of suggested guns. It's a strict state-mandated catalog of specific models that have been certified by the state.
Yeah, and if a manufacturer updates, like a spring or changes a cosmetic feature on a pistol...
It just drops off the roster entirely, right?
Exactly. Unless it passes a battery of new, incredibly stringent micro-stamping requirements, the state is essentially dictating which specific iterations of technology are deemed safe enough for commercial sale.
Which is wild. And assuming you find a model that is actually on that shrinking roster, you then move to the DR system, right? The dealer's record of sale.
Right, the mandatory state-run background check. And here is where the friction is really by design, because even if your background check clears instantly, and you have no criminal history whatsoever...
You still can't take it home?
Nope, you cannot take that firearm home. You are subject to a mandatory, strict 10-day waiting period, a cooling-off period.
10 always.
Plus, with very few exceptions for, licensed hunters, you must be 21 or older to purchase any firearm in the state.
Okay, so that's the current baseline. But looking at the rest of 2026, the state is going aggressively after new workarounds, too.
Oh, heavily. The tech restrictions are ramping up.
Yeah, by July 1st, this new law called AB 1127 goes into effect. It bans the sale of what they call machine gun convertible pistols, which is basically it's specifically targeting standard semi-automatics like your basic Glock.
Right, and it's important to understand why they're targeting them. It's because of a tiny aftermarket piece of plastic or metal.
The switch.
Exactly, often called a Glock switch. If you attach this illegal switch to the back of a standard Glock, it alters the firing mechanism. It allows the gun to fire continuously with a single pull of the trigger.
So it effectively turns a legally purchased handgun into an illegal, fully automatic machine gun.
Exactly. So the state's logic is, well, since the switch is too easy to make and install, we just have to restrict the base gun itself.
Which perfectly leads to the other new tech restrictions.
Yeah.
I mean, under SB 704, you can't even get a standalone firearm barrel shipped to your front door anymore.
Right. It has to go through a licensed FFL dealer.
They are trying to stop people from building these ghost guns from scratch. And then there is AB 1263, which honestly is, frankly, wild to think about from a tech perspective.
The 3D printing one?
Yeah. There is now strict criminal and civil liability just for sharing digital 3D printing files for firearms.
Which is a fascinating legal frontier in itself because, they are no longer just regulating a physical hunk of metal. They're regulating the distribution of the digital code that tells a printer how to make the metal or the polymer.
When you lay it all out like that, I mean, it sounds like acquiring a firearm in California is regulated more like adopting a child or like buying hazardous materials than purchasing a standard consumer good.
It really is.
It's a system built entirely around friction and verification.
And for decades, that architecture was incredibly sturdy. The state legislature designed it to prioritize collective public safety, and when those laws were inevitably challenged in court, California almost always won.
But that brings us back to the operating system downgrade you mentioned earlier.
Right, because the rules of the courtroom fundamentally changed in 2022.
Right. So if the state has spent decades engineering this massive machine of friction, why is it suddenly falling apart in front of federal judges?
Well, to understand that, we really need to look at how judges actually make decisions. Before 2022, courts used a legal test called intermediate scrutiny.
Okay, let's break that down without the legal jargon.
Sure. Think of intermediate scrutiny as a public interest balancing test.
Okay, so how does that scale actually work in practice? Like, give me an example.
Imagine a traffic law. You have a constitutional right to freely travel between states. Right. But the government obviously has an interest in making sure people don't die in car crashes, so they institute speed limits. If you challenge the speed limit in court, the judge acts as a referee with a scale.
Okay, a scale.
On one side, they put your right to travel. On the other side, the state puts its important government interest, which is public safety. The judge weighs them and says, well, the state's interest in preventing crashes is important enough, and a speed limit is a related way to solve it. The state wins.
So, applied to firearms, California would just show up to court, put their public health data and gun violence statistics on one side of the scale.
Exactly.
And the Second Amendment went on the other side. And the judge would almost always decide that saving lives outweighed the restriction on the right.
Right. The judge was allowed to balance the modern reality of the problem against the text of the Constitution. But then, in 2022, the Supreme Court handed down a landmark decision called NYSRPA v. Bruin.
The Bruin decision.
Yes. And with Bruin, the Supreme Court completely destroyed the scale. They threw the balancing test in the garbage.
They just eliminated it entirely.
Entirely. The Supreme Court established a strict philosophy of regionalism and historical tradition. The court's majority argued that modern judges do not possess the authority to balance the Second Amendment against modern public safety concerns. Because, in their view, the founders already completed that balancing test when they ratified the Bill of Rights in 1791.
Okay, let's unpack this, because I really have to push back on this, just on the sheer mechanics of it.
Go for it.
Are you telling me that we are legally forcing 2026 technology-like digital 3D printed gun code or semi-automatic pistols with Glock switches that can fire 20 rounds a second to be judged strictly by the rules that govern muskets in 1791?
That is exactly what is happening.
And how can a judge logically force a comparison when the fundamental nature of the object has changed so drastically?
What's fascinating here is that the Supreme Court justifies it by looking at other constitutional rights. I mean, it is a massive leap, but think about the First Amendment.
Okay. Free speech.
Right. It protects free speech.
Yeah.
Today, that means it protects speech on the internet, on global podcast networks, on television broadcasts. The founders only had access to printing presses and quill pens. Yet, we all agree the First Amendment applies to an iPhone. The court argues the Second Amendment must be treated exactly the same way. The technology of the era changes, but the underlying constitutional principle of self-defense does not.
I hear that, but, speech is fundamentally different from a kinetic projectile. Like, a mean tweet doesn't physically punch a hole through a wall.
It's a very common critique.
But regardless of whether we think it's a perfect analogy, this is the reality on the ground. This is the new legal operating system.
That's exactly right. The balancing of modern statistics is out. The new rule is the search for a historical analog.
A historical analog.
Yeah. If California wants to create a new barrier to purchasing a firearm today, they cannot simply point to a spreadsheet showing it reduces crime. They have to prove to a judge that a deeply similar law existed in the historical tradition of the late 18th or 19th centuries. They have to find a historical twin.
So if a new gun control law doesn't have a twin sibling from the founding era, it is deemed unconstitutional. That is a massive paradigm shift, which leads directly to the next question. If history is the new ruler, how does a judge measure modern hardware, like a 15-round magazine, against a 1791 standard?
That brings us to the most hotly debated legal concept in the federal courts right now, the common use doctrine.
Right.
This is the core of major ongoing cases like Miller v. Bonta, which deals with California's ban on assault weapons, and Duncan v. Bonta, which deals with high-capacity magazines.
Which California defines as anything holding more than 10 rounds, right?
Exactly.
So what does common use actually mean in a courtroom? Like, how many people have to own something for it to be considered common?
Well, the Supreme Court has signaled that if an arm is in common use for lawful purposes, it is categorically protected by the Constitution.
Okay.
And gun rights advocates point out that there are tens of millions of AR-15 style rifles and magazines holding over 10 rounds owned by law-abiding citizens across the country. They argue they are statistically as common as the Ford F-150, therefore you cannot ban them.
And California's response to that?
California counters by arguing that it doesn't matter how many units have been sold. They argue these specific items are militaristic, excessively dangerous, and just not suited for standard civilian self-defense.
Which has created this incredibly nuanced, almost surgical debate in the Ninth Circuit Court of Appeals right now in early 2026.
Oh, surgical is a good word for it.
Yeah, I was reading through the transcripts of the magazine ban case, and the judges aren't just arguing about the Second Amendment broadly. They're arguing about whether a 15-round magazine is legally a separate accessory or if it's a necessary component of the firearm itself.
Which might sound like legal hair splitting to some, but that distinction is everything under the Bruin standard.
Okay, let me see if I can map this out with an analogy.
Sure, let's hear it.
So the state is basically arguing the magazine is like a custom spoiler on a sports car. It's an extra accessory. You can ban the spoiler, take it off the car, and the car still drives perfectly fine.
Like the base car works.
Yeah. But the gun rights advocates are arguing that the magazine is the gas tank. If you ban the gas tank, the car physically cannot run. Therefore, banning the part is an unconstitutional ban on the entire protected system.
That is an incredibly precise way to look at it, because if the court rules that a magazine is the gas tank, a necessary component for the firearm to function, the state has almost no philosophical ground left to stand on. You cannot ban the necessary functional components of a right that is in common use.
Which brings up a fascinating chain reaction. Because if the state cannot legally ban the gas tank and they cannot ban the car itself, the next logical step for the government is to try and restrict where you are legally allowed to drive it.
Precisely. It's one thing to legally keep the hardware locked up in a safe in your bedroom, but the text of the Second Amendment protects the right to keep and bear arms.
And bearing implies carrying it out your front door.
Exactly.
This is where the friction spills out of the courts and directly onto the public sidewalks.
The landscape for concealed carry CCW, the permits, has been totally upended by these recent rulings. Before the Bruin decision, California was a may issue state.
May issue, meaning they had a choice.
Right. You could apply for a permit, but your local county sheriff had the subjective power to say, I don't think you have a good cause to carry a gun, and simply deny your application. Now they are forced to be a shall issue state.
Meaning the subjectivity is gone. If you meet the objective requirements, like passing the background check, taking the required 16 hours of training, paying the fees, the state shall issue you the permit.
Yep. Even to non-residents now, as of 2026.
Wow. But California wasn't just going to quietly hand over the public square, were they?
No, definitely not. They passed a massive countermeasure known as SB2.
Right.
The strategy of SB2 was essentially, fine, federal courts say we have to give you the plastic permit card, but we're going to define almost every location imaginable, parks, schools, banks, parking lots, private businesses, as sensitive places.
So they essentially tried to make it illegal to actually carry the gun anywhere outside your own property.
Exactly. But federal judges stepped in again and blocked those blanket bans. They ruled that you can't just declare the entire state a sensitive place to circumvent the Supreme Court.
Here's where it gets really interesting, though, because the most staggering consequence of this entire back and forth happened just a few months ago in January 2026 with a case called Baird v. Bonta.
Ah, yes. The open carry breakthrough. This caught a lot of legal analysts completely off guard.
Totally off guard, because California effectively outlawed open carry, which is carrying a firearm visibly in a holster on your hip in populated areas, years ago.
Right.
But in Baird, a Ninth Circuit panel actually struck down California's open carry ban. And the court's logic is just a masterclass in connecting the dots.
It really is.
They looked at the state's entire system and basically said, look, California, you have made concealed carry incredibly difficult, expensive, and time-consuming to obtain. If you construct a maze that makes concealed carry practically inaccessible for average citizens, and you simultaneously maintain a complete ban on open carry, you haven't just regulated the right, you have completely extinguished the right to bear arms.
The court drew a hard line there. The state is legally allowed to regulate the manner in which you carry a firearm. They can say, we prefer concealed only, or we prefer open only, but they cannot legally maneuver a citizen into a corner where it is virtually impossible to carry a firearm in any manner at all.
Okay, so follow the causality here. The state is losing ground on banning the hardware.
Right.
They're losing ground on banning the carrying of that hardware in public.
Also true.
What is left for a state legislature that is still deeply committed to a public safety mandate?
You target the fuel.
The fuel.
Yeah. You can't touch the gun, you squeeze the ammunition.
And this drops us right into what legal scholars are calling judicial limbo. Let's look at how California manages ammunition, because it is entirely unique.
It's very unique.
If you live in California, you cannot just go online, buy a bulk case of 9mm rounds, and have it shipped to your porch. You are required to physically go to a licensed vendor. And when you get to the cash register, you have to pass a mandatory background check just to buy the bullets.
And the mechanics of that check are directly tied to the state's massive data infrastructure. When you hand over your ID at the register, they run you through the automated firearm system, or AFS.
Okay.
If the state's computer shows that you already legally own a registered gun in that exact caliber, you pay a $5 fee, it takes a few minutes, and you buy your ammo.
But what if you aren't in the system?
Well, if you aren't in the AFS system, maybe you brought a gun with you when you moved to the state years ago but never registered it, you are subjected to a $19 basic check that can take days to clear.
Which brings us to the crescendo of this legal clash. Road v. Bonta. This case just had a massive en-banc hearing in front of the Ninth Circuit in March 2026.
Right.
And it perfectly encapsulates the two different operating systems trying to run at the same time. Proponents of the ammunition background check look at it through the old lens, the balancing test. They say, this is incredibly effective. It takes 5 minutes, it costs $5, and it actively stops convicted felons from buying bullets. The burden is completely negligible compared to the lives saved.
But under the new Supreme Court standard, opponents of the law argue that saving lives is legally irrelevant to the constitutional question.
Wow.
Yeah, the only test is history. And they argue, quite successfully in lower courts, that there is absolutely zero 18th century historical tradition of the government checking a citizen's background records and charging them a fee every time they wanted to buy a pouch of musket balls.
So they argue it's an unconstitutional backdoor tax on a right.
Exactly. It's not seen as a safety measure, but a tax on a core constitutional right.
I mean, it would be like the state charging you a $5 background check fee before you were allowed to buy printer ink or open a social media account.
That's a great comparison. And this is why we are in what analysts call the correction phase. California's entire legislative philosophy was, and still fundamentally is, built on a public health model.
Right.
They view gun violence as an epidemic to be managed through regulation, but the federal courts governing them are now strictly using an individual rights model based purely on text, history, and tradition.
So what does this all mean? which means laws like the ammunition background check, the magazine bans, the roster, they are just floating in this bizarre judicial limbo.
Yeah, limbo's the perfect word.
Because they are technically still active on the books.
Yeah.
You go to a store in California today, you still have to pay the fee and wait the 10 days. But philosophically, in the eyes of the federal courts, these laws are dead men walking.
Just waiting for a final, formal ruling from a Supreme Court that has made it abundantly clear they have zero patience for states trying to find clever workarounds to their 1791 standard.
So, to summarize the deep dive, the friction is immense. California is trying to govern modern lethal technology using a collective public safety model.
While the highest courts in the land are demanding they use an individual rights model frozen in the historical traditions of the 1700s and 1800s.
Right. So why should you, the listener, care about the minutia of a magazine ban or a background check fee, especially if you never intend to own a firearm? You should care because this philosophical clash is actively redefining the boundaries of government power and individual constitutional rights in real time.
It dictates the rules of the public spaces you walk through every day.
Exactly. It is testing the very limits of how much friction a government is allowed to apply to a constitutional right.
And, as we watch these rulings continue to drop throughout 2026, it leaves us with a deeply profound question to consider.
What's that?
Well, if the Supreme Court strictly demands a historical analog, a historical twin from the founding era for every new regulation, what happens to constitutional law when technology creates something that the founders couldn't have even dreamed of?
Oh, wow.
Whether it's the evolution of artificial intelligence, the complexities of digital privacy, or a completely new, unimaginable type of weaponry, how do you find a historical twin for something that has no history?
That is a phenomenal question to end on, and it really highlights that this earthquake isn't just shaking the foundation of gun laws, it is shaking the very foundation of how we will govern the future. Thank you for joining us on this deep dive. Keep asking questions, keep looking past the headlines, and remember, sometimes the legal concrete you are standing on is a lot more fluid than it appears.
We hope you enjoyed this week's episode. Tune in again.